Good morning, and thanks for joining us today, Monday, December 16th, 2019, for our webinar entitled New Laws for the New Year 2020. This is Denise Ketty, and I'm your moderator for this session. A couple of quick housekeeping notes before I introduce today's expert panel. Our webinar is going to run 60 minutes in total, so please take a moment now to visit the handout section area on your dashboard to download a copy of today's presentation. There are actually two handouts in this section today. Linda will go over the second handout during her section of the presentation. If you have questions during the presentation, please post them on the Q&A area of the dashboard anytime during the presentation. If you would like your question directed to a specific panelist, please note that when you are sending in your question. If you have any issues during the presentation, you can email me directly at denisemketty@gmail.com. Just a quick reminder, today's webinar is being recorded and all accompanying materials are protected by copyright. Our presentation today provides general information and does not constitute legal advice. The information offered during the webinar is, again, as of today, December 16th, 2019. And as always, we recommend that you consult with your own legal counsel to address your specific situation to ensure that you have the most current information on legal matters. Let me introduce you to our expert panel today. Our legal expert is Marla Merhab Robinson. Marla is the partner and head of transactional department at Merhab Robinson & Clarkson. Marla's reputation among her clients and peers is that she delivers personalized service and she is responsive, reliable, and very well respected. There are a lot of firms in Southern California that you can work with, but what sets Marla and her entire team apart from other legal firms is that she and the members of her firm have also worked in the corporate world. So this experience translates into a unique understanding of the business challenges you face, combined with the legal concerns that your company is confronted with on a daily basis. Please take a note that Marla has a new email address and website if you're planning to reach out to her, and it's listed on the slide. Our human capital expert today is Linda Duffy, President, Ethos Human Capital Solutions. Linda and her team are known for building the magic of human connection with their unique approach to consulting, recruiting, training, and also they offer payroll support programs. The Ethos team works with your company by developing strategies for your business leaders to get the right systems, people, and culture in place within your organization so that you as a business owner can focus on running your business and achieving your goals. Her clients range from high-tech businesses to manufacturing firms to nonprofits, and Linda is extremely well-versed in addressing the concerns of founder, CEO-led businesses. Thank you, Linda and Marla, for being here today. Linda, you're going to kick it off today.
I am. Thank you so much and welcome everybody. First, let me say my apologies for last week. I'm so sorry we had to reschedule this. We ended up taking my mom to the hospital and thankfully she is recovering nicely, but there's just no way we could have done this on Thursday of last week. So I appreciate everybody's indulgence on rescheduling that. So I don't need to read the agenda to you. We have a full agenda, and so I'm just going to move forward and get us started because we want to make sure that we have time to cover everything. And then answer any questions that you may have. So just as a little bit of an overview, there were actually over 1,000 bills that reached Governor Newsom's desk. He signed 870 of those, and many of those applied to employers. A couple that he vetoed that were pretty significant was AB 589. That would have required employers to develop a workers' bill of rights and to post that in the workplace. And then Senate Bill 218, this one was actually pretty scary to me, would have allowed Los Angeles County to basically come up with their own version of the Department of Family and Housing and their own discrimination ordinances. I can't even imagine how confusing that would be when the state has some and then Los Angeles County comes up with their own. All of the bills that we're going to talk about today, we've tried to reference the bill number. So if you want more information, you can always just Google the bill number and it'll take you to the actual text of the bill, which is how, of course, we do the research for this. And also all of these laws go into effect January 1st of 2020, unless we've made a note otherwise, and there's a couple of exceptions to that. All right, so the first thing I want to talk about is harassment prevention training. Everybody is familiar, hopefully, with this law that went into effect. The easiest way I could sort of explain this to everybody was to make a chart, because there's actually 3 different bills that were passed having to do with harassment prevention training. Of course, before any of these three, it was AB 1825. There were a couple successor bills to that as well that had to do with training managers and supervisors every 2 years for 2 hours if you had 50 or more employees. Now with SB 1343, that requirement dropped down to employers with 5 or more employees. So hopefully everybody out there, if you have 5 or more employees, you're in the process of getting everyone trained. So that was the first bill, and that required the training of current employees by January 1st of next year, and also training for newly hired and promoted employees within 6 months. There was also provision about seasonal and temp employees. Subsequently, they passed SB 778 and SB 530, which changed some of those deadlines. So SB 778 gave us the extension for another year. So for those of you that have 5 or more employees, you now have until the end of next year to get everyone trained. So it's 1 hour for non-supervisory employees and 2 hours for supervisory employees. SB 530 was a little bit different because it only dealt with the seasonal and temp employees, and that extended that deadline for a year as well, and also had another standard that the Department of Labor Standards Enforcement needed to develop policy and training standards for the construction industry. So that will be forthcoming, but not for another year. The one thing I really wanted to point out to everybody on this is that the requirement to train newly hired and promoted employees did not change. So your employees that are currently employed as of January 1st, you don't have to train them until December 31st of next year, and you would still be compliant. But unfortunately, if you hire somebody or if you promote someone from a non-supervisor into a supervisor management role, those employees have to be trained within 6 months of being hired or promoted. So you need to make a special note of that to make sure that you're training them within that time frame. So here are some action items for the harassment prevention training. Make sure obviously that you're going to train all of those newly hired and promoted employees within 6 months. Make sure that the training is being conducted by a qualified trainer and also includes all the content that's required. You also have a requirement to maintain all training records. And then beginning in a year, you want to make sure that any temp agency that you work with has a system for training their employees, because that standard is within 100 hours or 30 days, whichever is sooner. So if you call a temp agency and they send out an employee to you, you don't have the responsibility for training them, but the agency does, and you want to make sure that they're on top of that as well. Just a little commercial for Ethos. We do offer sexual harassment training, obviously. We have it on site where we can come out to you. We have it online in a couple of different ways, but via webinar, for example, and we also have it on demand for both managers and supervisors. We actually created our own content last year, took what we do in person and just created an online platform. So if you do need help with those newly hired or newly promoted employees, we can support you on that. We also can do it in English and Spanish. We can help you by writing your policy to make sure it's compliant. We do offer a confidential hotline for reporting incidents and issues, and we are also being proactive. We have a program where we'll actually survey your employees to document whether there's any issues, investigate them if anything gets reported, but otherwise we can document the fact that no issues were reported, which would come in handy if someone tries to make a claim down the road. There is a second handout, as Denise mentioned, next to the slides in the handout section, and that's just a flyer, and we're offering just a special to everyone on the webinar today with a 10% discount. So take a look at that. If you're interested in learning more, just reach out. Lactation accommodation, SB 142, on the surface doesn't seem like it's a big deal, but as they say, the devil's in the details. So when you look at it, there's actually a lot more than meets the eye. So last year, the law changed. So it changed some of the language to be in alignment with the federal requirements for what you had to do in terms of providing a space. Now it's taken a little bit of a step further. So not only does the lactation room have to be close to the employee's work area, shield from view, free from intrusion, and not a bathroom stall, which is what we had before, they also added some additional requirements. So the room must be safe, clean, and free of toxic or hazardous materials, has to contain a surface on which you can place a breast pump and other personal items, has seating, and also has access to electricity. But the other thing that was a new requirement is employers must provide access to a sink with running water and a refrigerator suitable for storing breast milk close to the employee's workspace. There is an undue hardship exception for employers with under 50 employees, but you actually have to, I think, apply for that exception. You want to make sure also that if you work in a building where there's like shared space, you can talk to the building owner to see if they have a specific room for that, but make sure that you're meeting all the requirements on the actual physical requirements of this. The other part of this, though, that gets even a little bit harder to comply with in some ways, is it introduces Labor Code Section 1034, where you have to have a written policy regarding lactation accommodation. So for those of you that have a handbook, you probably already have some sort of reference in there, but this goes a step further because it talks about, it has to include a statement about the employee's right to request lactation accommodation, the process by which they make the request, a statement about the employee's right to file a complaint with the labor commissioner for any violation. So it goes through and it has specific details like that. It also requires employers, like I said, to provide a written response if it cannot provide break time or location that complies with this policy. But this policy has to be in writing and it has to be given to all employees upon hire, and also when an employee asks about or requests parental leave. So you're going to have to come up with a process for doing that as well. They consider a violation of this to be basically like a meal or break period violation. And if there is a violation, you have to provide a 1 hour break period penalty. So here are some action items for lactation accommodation. You want to make sure you write the policy or you amend it if you already have one. Add the policy distribution to new hire paperwork if it's not in the handbook. It can be a standalone policy, that's fine. We usually recommend, just like the pamphlets that are required by California, that you just have an acknowledgement form for all of everything. Just add this one to the list. You want to make sure that you have some sort of checklist in place. So if somebody asks about a leave of absence for parental leave, that you're providing a copy of the policy. Take a look at physical space and identify possible locations for accommodation. And I think a really easy fix for the refrigerator requirement is just buy one of those small refrigerators that can be put in a cubicle, can be put in an office. And if you just have one, or depending on the size of your business too, you can just move them around as needed, so they can you can be compliant there. There are a few other different leave protections that came into play. We're not going to go through these in detail. A couple of them, like the first one, for example, is specific for airline employees. It just expands access to the California Family Rights Act. It has certain special eligibility requirements. If you have airline employees, Google that and you can review that one. There was a March 2019 Department of Labor opinion letter regarding designation of leaves. I'm not sure why this was a big issue, but I just wanted to mention it. Apparently some employees requested delay on the designation. I'm not sure why, but the opinion letter made it clear that employers must designate an FMLA leave within 5 days, even if the employer requests such a delay. The bottom part of this is actually a little bit more significant. AB 1223 has to do with organ donation leaves. Again, honestly, I don't know how many organs one person can donate, but apparently more than one. So it requires employers to provide an additional unpaid leave of absence up to 30 days per year to an employee donated an organ. Currently, this is the only type of leave, bone marrow and organ donation, that could potentially be paid by the employer in California. Everything else is unpaid. Hopefully you know that organ donation, if someone wants time off, they can take up to 30 days. And if you can require them to use some of their vacation and sick, but the remaining portion is paid for by the employer. This basically says, in addition to that leave, you have to give them an additional unpaid leave if they want to donate a second organ. So make sure that you update your handbook leave policy to be compliant with that. Paid family leave benefits beginning July 1st of this year, for the coming year, paid family leave is going to be extended from 6 to 8 weeks under Senate Bill 83. So if employees, that's nothing for you have to do, just know that that's the good news for employees, that if they're going to take time off, and again, this paid family leave does not give them time off, but if they qualify for time off under FMLA or something else, or under a company policy, they can receive up to 8 weeks of benefits from the state. All right, discrimination. Couple changes here, or one significant one. Senate Bill 188 expands FEHA, so Fair Employment and Housing Act, to prohibit discrimination against employees based on their natural hairstyles. So it actually amended, the Department of Fair Employment and Housing amended the definition of race under FEHA to include traits historically associated with race, including but not limited to hair texture and protective hairstyles, such as braids, locks, and twists. That's the language out of the statute. So what you want to do is review and amend your dress code or grooming policies as needed. Make sure that you're expanding your discrimination and harassment prevention policies to include the expanded definition of race, and make sure you're training your hiring managers, HR, anyone who interviews candidates, not to discriminate against anybody if they show up with anything that would be considered a protective hairstyle. And I've had this come up recently with a client who said, well, this woman has like bright red hair. Is that protected? And I said, no, because color is not something that they're talking about here, right? Employees can't show up with green hair, purple hair if you don't want them to. You can still make that change, but you want to make sure that if they're showing up with, braids or something that's historically associated with race, that you're not telling them that they have to change their hairstyle, or you're not refusing to hire them. All right, FEHA also claimed the statute of limitations. So if somebody wants to bring a claim under the Fair Employment and Housing Act for discrimination, harassment, retaliation, something like that, up until now, it's been 1 year. AB 9 extends that statute of limitations to 3 years. So the issue with this, obviously, is they have longer to file a claim, but the issue is they have 3 years to file the claim, and they have another year to serve you with a lawsuit. So potentially you could not know about it for 4 years after it happens. So you want to make sure that all issues are addressed, obviously, as you find out about them, but also that you document everything really well when it happens, so everybody's memory is clear. Because if you get a lawsuit 4 years down the road, people may not be there. There may be an issue of remembering exactly what happened. So you want to make sure that you're documenting everything clearly. Just a quick change here, domestic partnerships. I actually did not know that currently domestic partnerships in California, I knew it was protected, but I didn't know that it had to either be members of the same sex or members of the opposite sex over 62 years of age, or 62 or older. They changed that, so now it's 2 adults over the age of 18 can enter into a domestic partnership. So review anything that includes that definition. I would say pay particular attention to benefit plans. That's typically where we see this come up. So talk to your insurance carriers, make sure that they know in case you have employees that want to, cover each other as domestic partners. Flexible spending accounts. So those of you that have an FSA account, at the end of the year, we have this use it or lose it provision. So on, for reimbursement of medical expenses, childcare, whatever you're using it for, the new law says you have to notify employees of any deadline to withdraw funds before the plan's year in 2 different ways. So they want to make sure people are not losing their money, right? So as you get close to your plan year, which for most employers, in my experience, has been a calendar year, you can come up with 2 different ways to notify them, one of which can be electronic. So you can email them, you can call them, you can text message, you can have a group meeting, you can do whatever you want to do, but 2 different ways. Interestingly, there's no time limit in the statute. I read it again last night to make sure. It doesn't tell you, how soon before the plan year end or anything like that. So think about that, just come up with 2 different ways to notify them. California, back in 2016, then Governor Brown signed Senate Bill 1234, which required California to develop a workplace retirement savings program. And this was for private sector workers if the employer did not offer a retirement plan like a 401k. So employers are required to register by certain dates depending on the size of the employer. So hopefully anybody on here that has 100 or more employees, you've already registered, because there are penalties for not registering. There's no fiduciary liability to the employer. There's no cost to the employer, but there are penalties if you don't register your business. And you can just go to the CalSavers website. It'll walk you through. There's a whole website for employers. There's a whole website for employees. So you just go through and take a look at that website and then figure out when your deadline is. Mark your calendar now just to make sure that you register in time. There were a few bills on workplace health and safety. Again, we're not going to go into a lot of detail here, but AB 203 is about construction employees. If they work in an area where it could be reasonably anticipated that they're going to be exposed to valley fever, which is a fungus, you have to provide them with training before they begin work and then annually thereafter, and there's requirements about the training. So if you have employees that work, and I think the closest county I saw was Ventura County, but there's a list of counties, but it also says, you know, including but not limited to these counties. The next two have to do with Cal OSHA's definition of serious injury or illness and serious exposure. So currently, if you have an employee that is hospitalized for more than 24 hours, you must report it to Cal OSHA. This actually changes that requirement to say employers have to report all hospitalizations. So if you have an employee that gets injured, they go to the hospital, you must notify OSHA. AB 1804 says you must notify them through an online platform, but of course they haven't developed it yet. So until it's developed, you can continue to notify them by telephone or email. And then after that, they're going to request you to notify them through the platform that they will publicize. So you want to make sure that you are training managers, HR, and all safety personnel on the new rules. Make sure you develop a procedure for reporting hospitalizations, and then review your handbook and your injury illness prevention program for any references to notification of Cal OSHA. I would just suggest that you pinpoint somebody or something, some process for notification so you don't have multiple people doing it. This one also has to do with workplace safety. This is specific to gun violence and attempt to cut down on any sort of issues in a workplace having to do with restraining orders. So currently, it's immediate family members, law enforcement officers, other people can petition a court to issue a gun violence restraining order if they believe that an individual can pose serious harm to themselves or somebody else. And it says prohibiting individuals from having in their custody or control, owning, purchasing, possessing, or receiving, or attempting to purchase or receive a firearm or ammunition. So if you can show that there is a substantial likelihood of significant danger in the near future by somebody accessing a firearm, then you're allowed to petition a court to get a restraining order. So consider whether you want to include some sort of instructions in the workplace violence section of your handbook. In our handbook template, we have a list of, if any of these things happen, we want you to come and tell us about it. And we just added as another line item on that, if, just to say if you think that there's significant danger posed. Okay, last couple of slides for me before I turn it over to Marla. Everybody probably knows also minimum wage is going up January 1st. So if you have 25 or fewer employees, it's jumping by $1 up to 12. If you have 26 or more, it jumps by $1 up to 13. So you want to take a look at that. Make sure that you're paying all of your employees at least minimum wage. Remember to check local ordinances and county rules for higher minimum wage requirements. There are something like 40 different local ordinances. I even found one for Anaheim last night, but it was very narrowly focused on certain industries. So there are certain things like I think Long Beach has one, but it's specific to hotel, the hotel industry. So you want to take a look at local ordinances, and again, just you can just Google your city minimum wage, something like that, or county minimum wage. And then also always look at addressing wage compression issues. And wage compression happens because you may have somebody that's been here a while making $12 or $13 an hour. Now you're bumping up, the newly hired person to at the same rate of pay, and you're asking the person that's been here for 1 or 2 years to be training them. So think about how you want to deal with that, if you want to make additional adjustments to those people to give a little bit of space in between. With minimum wage comes a new minimum exempt salary requirement. So again, it's twice the state minimum wage. So all we did here is you just take what's either $12 or $13 an hour, multiplied by 2, multiplied by 2080, and that will give you the new minimum salary. So if you have 25 or fewer employees, all of your exempt employees need to be making close to $50,000 a year. If you have 26 or more employees, that number jumps up to $54,000 a year. So when we come in to do an audit, we ask for a list of employees. We just literally just sort it, and if we see that they're exempt, it's an easy look to see, hey, either they're above that threshold or below that threshold. So setting aside any sort of misclassification issues, which is the second topic, just make sure that they're meeting that minimum salary. There's also some minimum salaries we didn't include here for computer professionals and doctors. They're much higher, they're 6 figures. So if you try to make someone exempt as a computer professional, there's a very narrow definition, and just know that there's a much higher minimum salary. The other thing to know is Department of Labor is raising the federal minimum exempt salary for the first time in a really long time. But look how much lower it is, right, than California. So $35,568 per year. And then they also have a highly compensated standard that's getting raised from 100,000 to 107,432. I only include that because obviously you don't have the option of paying your California employees 35,568, but you may have employees in other states, so you don't have to pay them the California rate. You can pay them according to the Department of Labor rate. And with that, I'm going to turn it over to Marla.
Thank you, Linda. I hope you can hear me. First of all, we're so glad to hear that your mom is recuperating. I have to apologize as well. I'm actually coming to you from my car because we have a fire in our building this morning that required me to exit. So I hope everybody can hear me, and I hope it's not too loud. The first thing I'm going to talk about is AB5, which if you haven't heard about, you must have your head in the sand because this is what the lawyers are calling a game changer as a result of the Dynamex case. We've been calling it Dynamex, and Linda had the pleasure of hearing the attorneys speak who actually worked on the case, and said, no, it's Dynamex. We fall back and forth and call it the wrong thing occasionally. But AB5 codifies the test that came out of the case and goes beyond. It expands well beyond the case. You may recall that the case was limited at the time. The court specifically said it was limited to wage order claims. Well, now it's not limited to wage order claims anymore at all. It's related to overtime and wage hour issues, workers' comp coverage, payroll withholdings, payment of the employer side taxes, business expenses, final pay requirements, and local and municipal requirements for health insurance. It has expanded. It is pages and pages of a new statute, which will be, for those of you who are code geeks, will be Labor Code 2750.3. This was just signed into law November 19th, 9/19/19. So it's still being digested by all the attorneys, and I'm sure we will get some additional statutes coming out of it as well, like Linda pointed out with the sexual harassment training. But the big thing to take away here is to know that you're probably not going to have a worker who's an independent contractor. You might recall in the case, the court kept referring to plumbers and electricians, and that's because of item B. So you have to meet all 3 criteria for independent contractor classification to be correct. The first is that the worker is free from the hiring entity's control and direction, and that's in connection with both the performance of the work under the contract and in actually performing the work. The second, and remember this is an and, you have to meet all 3, A, B, and C. And B is the one that usually knocks out every worker. The worker performs work that's outside the usual course of the hiring entity's business. The example given by the court over and over was that I'm a law firm, so I'm not doing any plumbing or electrical work. So if a plumber comes in to fix my sink or an electrician comes in to fix my lights, that's outside my usual course. And the courts even went so far to say, the California Supreme Court went so far to say, we're going to look to what's on your website, employer. We're going to look at your marketing materials. What are you telling people you're doing? There's a big fight right now in this area, as you might know, excuse me, with Lyft and Uber because their workers are saying, we're doing what you're doing. You know, you've told everybody you're a rideshare company, and they're saying, no, 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 we're not a rideshare company. We are a software platform that we allow you to use, and we're just providing you that software, and you're a rideshare company. We'll have to see where all that comes out because it's still being fought in all the courts. And then and C, the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. So that their business has to be of the same nature that they're performing. So there are exceptions. There are lists and lists of exceptions. We have put some here: insurance brokers, physicians, lawyers, registered securities brokers, real estate agents. But here's the caveat. The exception doesn't mean, oh, okay, you are now an independent contractor. That's not correct. The exception means, okay, we're going to take you out of the A plus B plus C. We're going to put you into the old test, which was called the Borello test. It's a multi-factor test. The principal factor of it is whether the person to whom services is rendered has the right to control the manner and means of accomplishing the desired result. You might, the Borello test is 9 factors, and I'll go through them, but you might know that the IRS used similar factors, but they had 21. So the 9 Borello factors are, the first is the right to discharge at will without cause. That leads more towards a finding of an employee. The second is whether the one performing the services is engaged in a distinct occupation or business. Think of the plumber, the electrician, the HR consultant who runs their own business. The third is the kind of occupation, with reference to whether in the locality the work is usually done under the direction of a principal or by a specialist without supervision. Again, going back to the principal factor of control. The fourth is the skill required. Those of higher skill are more likely to be found to be in the contractor space. The fifth, whether the principal or the worker supplies the instrumentalities, tools, and place of work for the person doing the work. This is an area where I've seen before we had Dynamics and before we had AB5, a lot of employers lose the classification because the person was coming to their place, using their computers, using their tools and instrumentalities. The sixth is the length of time for which the services are to be performed. And this is generally, again, goes towards like the at will. An employee, there's no set time to perform the services, they're just always there. The seventh is the method of payment, whether it's by the time, which would lead towards an employee, or by the job. The eighth is whether or not the work is part of the regular business of the principal. Think of item B on the ABC. And the last factor in Borello is whether or not the parties believe they are creating a relationship of employer-employee. So that goes to the contract that you would have in place, your written document. But unfortunately, I have to advise employers all the time, the document itself and the fact you and the worker want it to be an independent contractor relationship is not going to be determinative ever by itself, ever. And it's unfortunate. I understand that. I've had the very unfortunate job of, since last year in the Dynamics case, having to sit down with employers and say, you're just never going to get this worker as an independent contractor. It doesn't work. And primarily it's because of factor B in the ABC test. You just can't get them out of your business. So here's some additional exceptions. Direct sales representatives, which is a little bit of a misnomer because it's not what you're thinking, direct sales. It's for your company. It's more like the guy who comes to the house to sell the vacuum cleaner, if they still do that. Professional services, photographers, licensed estheticians, bona fide business-to-business contracting relationships. I use Linda as an example very often for independent contractor classification, where it works. She comes into your company, which may not have an HR department, and she provides HR services. She's an entity. She's a corporation. She hires her own employees that do the same work. She has had this established business for many, many years. She's a perfect example of where you can get to that status. But there are more examples of where you can't, I'm afraid. So your action items, if you have independent contractors or if you have workers classified as independent contractors, make sure you review the agreements and make sure you review what they're doing, either with an attorney, with a HR consultant like Linda. You want to make sure, because even with the exceptions, there's fine print rules that might push them one way or the other. We've done some really heavy analysis on some, and others, 99% of them we can tell you no right away. They're not independent contractors. No one's ever happy about it. And then the really critical things, discuss with an attorney or someone like Linda the options for reclassifying and how you're going to deal with it. And every employer that I've worked with is different because their level of risk that they're willing to take is different. And so we deal with it on a go-forward basis in different ways. And just know that if you're paying somebody both ways as an independent contractor and a W-2 employee, you're just a red flag everywhere for an audit by the IRS and by the EDD. And keep in mind, the only people that can determine whether or not the classification is correct is the courts, the administrators, the Division of Labor, the IRS, or the EDD. Those are the people that would come and say, you're doing it wrong. Okay, so then we're going to go through a couple cases. I'm not going to spend much time on the cases. We didn't have anything after Dynamics that was explosive, but Gonzalez versus San Gabriel Transit is also very frightening because it held that the ABC test applies retroactively to pending litigation. Claims brought under wage orders and the labor code, rooted in one or more wage orders or predicated on conduct alleged to have violated a wage order. So that means that us as employers are responsible for a law that we didn't even know existed, didn't exist, beg your pardon, not even know, but didn't exist, and we're still responsible to have complied with it. It's very frightening. And this case, just to give you an idea, was filed in 2014, almost 5 years before AB 5 was even adopted into law. It doesn't seem fair, does it? So arbitration agreements, this is huge. I apologize, I don't have the code section for AB 51, but it effectively bans mandatory arbitration agreements. Employees may voluntarily enter into such agreements, and it doesn't apply to any that are already entered into before January 1, 2020. It creates penalties for requiring employees to sign an agreement, possible PAGA claims, authorizes attorney's fees for prevailing an employee, and here's the scary part, imposes criminal penalties for violations. SB 707 requires employers to pay the cost of arbitration within 30 days after they are due or be considered a breach of the agreement. And then the employer loses the right to compel the arbitration. And that's a good thing because that law's been in effect for a long time that employers have to pay, and it's been abused, unfortunately, by some employers. But this last year, Governor Brown vetoed a virtually identical bill to AB 51 because he said it plainly violates federal law. I happen to agree with him on that. I think this will be challenged. Federal law has the Federal Arbitration Act, which really is a public policy of promoting arbitration. But the takeaway here is on your action items, if you're going to do arbitration agreements, make sure you use someone like Linda or an attorney to help you correctly write them. We're strongly putting language on the top and bold and caps that says this is voluntary. You don't have to do it because you don't want to create an argument that you forced the employee and then be in violation of the law. If you want to explain to employees or sell, as we have here, the benefits for both, it's generally quicker for the employee. It's cheaper, not for the employer. Then you've got to review your onboarding materials and your handbooks to remove any suggestion of mandatory language, and also train your people to that effect as well. And if you're going to do it before year end, also seek legal counsel. But I'd say even after year end, even more so, seek legal counsel. So Lamps Plus versus Varela. In this case, a party cannot be forced under the Federal Arbitration Act to submit to class arbitration unless the parties explicitly agreed to do so. This case is one of those few that just kind of makes sense. If I didn't sign the arbitration agreement, I shouldn't have to be forced to be in that class. And in this case, it was actually the worker that was trying to force a class action, and Lamps Plus was saying, no, this should just be his individual case in the arbitration, and that's where the court felt it should be. I apologize, I hope it's not too noisy. Okay, settlement agreements. Employers cannot prohibit or restrict an aggrieved employee from working for the employer by including a no rehire clause in settlement agreements. This was something we used to do all the time, but you can't do it anymore. There's an exception for employees found to have engaged in sexual assault or harassment. So again, this is one of those webinars. We have a lot of action items. There's a lot of takeaways here, so I hope you act on them. remove any prohibition against rehire from settlement agreements you're using. If you're using a form, it might be time to look at updating that form. And that's the second item, having it reviewed by council. We put LaCaim House versus DLSE in only because there are a lot of residential care facilities out there now. That's what this applies to. The court held that even if the meal period is on duty, the meal period still needs to last at least 30 minutes. Very, very few exceptions, industries where it's allowed to have an on-duty meal period. This is one of them, residential homes, but it still has to be 30 minutes. And the big action item here is just ask employees, do you have time to eat your meal while you're working? Are you rushing? What can we do to reschedule? So Rodriguez versus Nike Retail Services. Nike required retail employees to submit to exit inspections when leaving the store on break or at the end of the day, so both times. And they varied in length and after punching out. And that's really why the court said, no, Nike, you can't use the federal de minimis rule. You might have heard the federal de minimis rule said you don't have to pay, employers don't have to pay if it's such a small amount of time. It's not really affecting the time worked by the employee. But there was a genuine dispute here as to how long that was. So they couldn't use that rule unless they could prove that it was actually de minimis. And two pending cases. The first one is Friedkin versus Apple. It's nearly identical to the Nike case, and it's going to be heard by the same court. These are Apple employees who were having their personal belongings searched by store management prior to exiting at any time, rest time, and after clocking out at the end of the day. So that'll be decided. And then Donahue versus AMN, an employer is asking to be entitled to use a rounding policy for timekeeping. It's always been held to be okay if it's fair and neutral on its face. So that'll be the question here, is whether it is fair and neutral on its face. And with that, I think I'm done. And I do not have the ability to see any questions or answers since I'm sitting in the car. So if there's a question that I need to answer, I'll have to have somebody read it to me.
Well, and I will tell you, because Denise apparently does not have the ability to see questions either today. So,
well, it's a Monday, you know.
It is a Monday, exactly. So I will just tell everybody I can see the questions. I move forward to this slide in case people want to jump off. I can't believe we got through all that content in 40 minutes, Marla. If you have any questions.
Well, it's so hot in my car, I was going kind of fast.
Well, crack a window now, you're good. If you have questions regarding the new laws for 2020, please reach out to one of us. We're happy to help you. I'm also going to tell you that our next webinar is scheduled for January 23rd. You can see the link to register right there. If you've downloaded the handout from today, you should be able to click on that in the PDF and get there. We're going to talk about record keeping. We haven't done that webinar in about 5 years, and there's some changes. So we'll go through documents that are required to give people, record keeping rules in terms of how long you should keep them, all sorts of things like that. Okay, so I'm going to just click through and remind everybody also, if you have a question, just to type it into the question panel, the Q&A panel on your dashboard. Let's see. So it says Megan asked for harassment training, what is a qualified trainer? Megan, that's actually in the requirements. It's actually in the statute, but I don't remember off the top of my head. But there is specific rules in terms of the level of experience. I don't know if Marla knows off the top of her head. I'd have to look it up for you. But you can't, like, we've had this happen before. I remember a time last year sometime actually that one of Marla's clients, we couldn't be there to do training. He said, oh, I'll just have my son do it. And Marla's like, no. Like, your son's not qualified to do training, right? So if you want to know specifically, email me and I will shoot you the answer. Trish asks, on lactation, is there a 1-year limit or other time limit for lactation accommodation? I don't remember any sort of time limit in the statute on that. Marla, do you remember anything about that?
I don't, but I do not, and that's a great question. We'll have to look it up and get back, because I don't know. That's a really good question. I have particular interest because I have somebody who's having a baby next year.
Well, as you do that research, look at Trisha's follow-up question, which is, may an employer require a doctor's note to accommodate periods longer than 1 year or for more frequent or longer breaks than typical? So I do know that the old law said that if the break time didn't coincide with the normal break time, then any subsequent breaks are unpaid. The new law seems to remove that language, and so I don't know how it's going to be enforced. I don't know if there's a requirement to go through some sort of interactive process, or or if it's considered a reasonable accommodation to provide additional break time. I haven't had to deal with this one, so again, maybe Marla has some input on that.
Yeah, I don't yet, but I do know that under the federal law, lactation was only for 1 year, but California, under the existing law before the changes, I don't think it had any time limitation.
Okay, and
Which
Cindy
is not
Henry,
surprising.
another HR consultant, says she thinks it's 1 year. So Trish,
Well, that's
maybe
under the federal law. That's correct. That's correct under federal law, but I don't believe so under California law.
okay. So again, we can look into that and maybe get an answer to everybody if we can figure that out. Karen asks, can you please clarify the sexual harassment training deadlines for existing supervisors employees? Is it 1/1/20 or 1/1/21? So Karen, this one I do know. So for existing employees, you have an extension through next year. If you did training this year, that's great. You're good for 2 years. But if you have current employees as of 12/31, you have until next year 12/31 to get it done, right? Or by 1/1/21. The problem again is if you hire somebody on January 2nd, you have to train them within 6 months. If you promote somebody January 2nd, you have to train them within 6 months as a supervisor or manager. Okay, so that's the issue on that one.
So I would recommend train everybody now. Just get them trained, because it's
exactly.
People are getting confused also about it doesn't change the requirement on the over 50 for the 2 hours.
Right. Yeah. So that law stays in effect as well. Okay. Angie asks, what constitutes a highly compensated employee? So Angie, I think you're probably referring to the minimum exempt salary slide. And honestly, it doesn't matter in California. But Marla, can you speak to that in terms of the highly compensated employee for exemption under federal guidelines?
Well, you want me to do that because you know this is one of my pet peeves. I believe very strongly we should have a similar law in California that says if you make this high compensation, you're exempt from overtime. That's the simple way to put it. I shouldn't have to go through all this whole analysis. If you make such a high salary that I expect you to work more than 40 hours a week, and you know it and I know it, then you should be exempt. Again, it doesn't apply here in California. Write your legislator. It would be apply in other states. So if you have employees in other states, you might be able to use that federal exemption.
Great. Hopefully that answered the question. Okay, and then Trish says sexual harassment training, does the temp requirement of 30 days also apply to directly hired temporary employees not hired through an agency? Trish, I believe it does, but I will go back and look at that one for you to make sure. When I was reading this, that's one of the things that jumped out at me over the last couple of weeks, because a lot of people are confused about that 6-month requirement. But if you hire somebody intentionally with the intent of not employing them for more than 6 months, then yes, I believe you still have that same requirement. Most employers are going to go through a temp agency, so that's why I focus on that. But I can get you an answer regarding a direct hire for less than 6 months. And I do not see any other questions. So last chance for everybody if you want to jump on here. Okay, Angie came up with another question. What if you don't have a spare room or office? How do you accommodate the private area for lactation? Do we need to build a room specifically for lactation? Angie, you don't need to build a room. I don't know how many employees you have at your company. There is an undue hardship provision if you have fewer than 50. If you have more than 50 employees, you are going to have to come up with a solution. So you could take a look at, maybe using somebody's office. It can be a temporary situation. It could be a conference room, they said. But the lactation accommodation takes precedence, right? So it's not okay to say, well, you have to wait till that meeting's over before you can go into the conference room. It takes precedence, okay? But you don't have to necessarily build a new room. Obviously, as Marla and I always point out, the larger the company, the less flexibility you're going to have on this, because you're not going to have an undue hardship provision. So what Boeing's required to do, they may have to build a room, right? What you're required to do is probably not build a room.
And you can be creative. Just by way of example, we just recently, last year or the year before, had an employee who was lactating, and so we just put blinds up in her office so that you could not see in from anywhere. She locked her door, and we had a sign on the door that says "Do not disturb." The kitchen and the sink and the refrigeration were in a different room, but I don't think that has to be in the same room. Just the ability to have electricity and to put the pump on a table or something.
Right, exactly. Okay, Sherry asks on domestic partnerships, do they have to file anything with the state and have it certified or employee only, or does the employee just have to relate the information to the employer? Sherry, there is a way for them to file with the state of California. I don't know the process for doing that. And I would say, again, most of the time this is going to come up with respect to benefit plans, and I would refer you back to your insurance carrier to ask them what the requirement is. Is there something that they have to sign? Sometimes I've seen it where an insurance carrier just has like a form that has to be filled out to say like, hey, this is, you know, we both sign saying that we're in a committed relationship and whatever else. Okay, there is a question on separation and severance agreements. It says separation and severance agreement is being signed this week, but still includes no rehire language. Does it not apply after 1/1/20? So David, if you are or if you are giving a separation agreement to an employee before the end of the year, you can absolutely continue to include the no rehire clause in that. It's after the beginning of the year that you have to remove that language from any sort of separation agreement, which again is sort of a bummer. It's like, hey, you know, we want you to, you know, we want you to leave. We've agreed you're going to leave. We've agreed you're not going to sue us, but then you're going to turn around, you know, a month later and reapply for a job, and we're not going to hire you. And then what happens, right? So that's probably one of my.
Unfortunately, that happens. It's very unfortunate, but these employees and their lawyers know this, and I've had them do that exact same thing. Get paid
Yeah.
a severance, get released, and wait 6 months and apply again.
Yeah, I had that with a client too. They had a class action lawsuit, and the attorney that was representing the group, then all of a sudden some of those employees came back and started applying again, and then they're getting into situations with like, well, why aren't you hiring me? Are you discriminating against me? So yeah, it's one of my least favorite things. One of the least favorite laws that went into effect. There is an exception for that, just so you know, if the employee was found to have engaged in sexual assault or sexual harassment, you can prohibit them from coming back. David also says if the employee is over 40, they still get 21 days to rescind. Hold on, I can't read the rest of that. Hold on 1 second. I lost my questions. Can employee hold out? David, I'm not sure what you mean by that. If the employee is over 40, yes, under the Older Worker Benefit Protection Act, they get 21, they don't get 21 days to rescind, they get 21 days to consider the agreement, and then they have 7 days if they want to revoke it. So I'm not sure what you mean by can employee hold out. So if you want to, you know, email me or call me later, we can talk about that. But they do get, if they're over 40, they get 21 days by law to consider. They don't have to take 21 days, but you have to give it to them. Any final questions? Because I think we have actually covered all the content and answered questions, which is a miracle with Marla in a car in her with a fire in her building. So hopefully everybody's okay in your building, Marla.
I'm going to go try and get back in and see.
There you go. Hopefully you don't have to walk up 10 flights of stairs. So thank you so much, everybody, for joining us today. Really appreciate your attendance. Again, our apologies for all of the rescheduling. Make sure you download the slides if you haven't done so already. And if you need help with any of these laws, just go ahead and reach out to us and go ahead and register for our next webinar after the new year. And with that, I'll say Merry Christmas, Happy Hanukkah, Happy Holidays to everybody, and Happy New Year.